Okay, all right, over to you, Fareez.
Thank you very much. Good evening, everyone. I don't know why they gave me the evening session. It's always the toughest crowd to entertain. But my name is Fareez, and I run a law firm. But we curated the firm specifically to accommodate business owners. So we try to make it a one-stop solution. So we're actually a registered company secretary, registered advocate solicitor, registered trademark agent. So we try and make it a one-stop solution for business owners. So what I'm going to try to do for you today is that I'm not going to teach you the law. It's very boring. Like, in fact, for me, the most boring thing in law school was learning law. So what I'm going to try to do for you today is I'm going to try and simplify the whole thing and try and interpret for you how the law will affect you in terms of operating your startup. And first thing I want to highlight for you today is what we'll cover. We'll be covering a bit about company structure, co-founders arrangement, fundraising issues, the common agreements that startup will need, as well as how you want to find the right legal advisor for yourself. So I also want to highlight throughout the whole course is some of the mistakes that a lot of founders do, and these are the mistakes that we normally have to fix, and I want to highlight to you so that you don't fall under this category, because it's not really a big problem sometimes, but it's good that you avoid them early on so that you don't have to spend a lot of time fixing it and you can focus on other stuff. First things first is not setting up as a company. If you're planning to set up doing a startup, obviously you want to scale it up. And if you don't set up as a company, what's going to happen later on is that you got to convert whatever entity that you are using currently into a company eventually, if you're planning to scale up. If you're just planning to set up one grocery shop, then it shouldn't be an issue. But if we're talking about scaling your business tremendously, then outrightly I would advise you to set up a company immediately. And reason being is that limited liability partnership and sole proprietorship are difficult to scale up. The model just doesn't promote scaling up. One of the big reasons is because no equity capability. That means you cannot offer shares in return for capital to operate the business. But company allows you to do that. And some people say, Fareez, it's okay, I'll do it now and then later I'll convert. There's no such provision. The law doesn't have anything to say that if you're using this model, you can convert into a Sendirian Berhad later. From a Sendirian Berhad, you can convert to an LLP, but it's not, the other way around is not permitted. Now, the biggest problem is not really so much about being able to convert or not. Some people say, Fareez, all I can do is just, I run it as an enterprise first. If business is doing well, I'll start a company. Now, the problem with that is the bank account is attached to the entity. So your bank statement from your enterprise, your LLP, when you convert into a Sendirian Berhad, is not the same. So the banks view you, or your financiers will view you as starting fresh. So ideally, you don't want to lose that year of operation. And those records where you are making very, very good revenue, which will allow you to gear up and propel your business, is going to disappear when you convert, or when you change into a different entity. So ideally, if you spend a little bit, you will realize that, hey, it's better to start as a Sendirian Berhad. And now maintaining and setting up a Sendirian Berhad is not expensive. They have made it, they've changed the regulation under the New Companies Act 2016. The cost went down, the requirement went down. You just need one person now. So it's quite easy to set up a company. So there's really no excuse. Unless you're really, really not sure, then maybe you can consider this other entity. But otherwise, my advice is company immediately. Okay, so now a lot of founders set up a company, bring in, if you're a sole co-founder, then it's fine. But when you start bringing in co-founders to help you with other parts of your business, then all these issues about share ownership becomes prevalent. That's why you need to understand how companies work in the first place before you can decide how am I going to manage my relationship with my co-founders or my investors or my other shareholders. But before that, just a little bit of concept of a company. Why people opt for company is because it's viewed under the law as separate legal entity. It's not the same. So a company and the owners, that means the shareholders, the directors, the employees are not the same entity. So whatever that is owed by the company is not owed by the owners, not owed by the directors. It's owed by the company itself. So the company can own assets under its own name, can buy property under its own name, can suit under its own name, okay? Or be sued under its own name. So there's this line, what we call a corporate veil. It's a term to say that there's a separation between the company, okay? But of course, the company is not a living organism, so it's being controlled by the shareholders and the directors. Now, because of this model, it allows it to have that equity model. And the question has always been, is it the best model for startup? For me, a company is the perfect legal entity for any business that is planning to grow very, very fast. And if we're talking about startup, then obviously you want to have a very, very healthy growth potential. So that's why I would always recommend startups to go for a Sendirian Berhad. Okay. Now, having set up a company, you got to understand the dynamics, how it works. You got to see it like a country or a state, where you will have the shareholders, who is the owner, who will then appoint the directors, and then the directors will then manage the day-to-day operation. So you have to see these roles as very separately. A lot of times, founders don't see the difference because they are the shareholders, they are the director, and they are the employee, so they do whatever they like without distinguishing the power that is given to you. So each role will give you different power, and that power derives from the Companies Act or the constitution of the company. Under the default setting of the new Companies Act, you don't automatically have a company's constitution. You can have one, but it's not by default anymore. So it's an opt-in model, not an opt-out. Before this, it was an opt-out, and you automatically have to opt into a constitution that is template from the old Companies Act, but now no more. So when you set up a new company, or any company that is after February 2016, you have to observe the Companies Act only. But for those who are incorporated before February 2016, must observe the Companies Act and the Constitution. Okay? So Constitution is like the document where the shareholders, directors refer to when it comes to their authority inside the company. If the Constitution is not there, then you refer to the Companies Act. Okay? So the content, of course, you can check with your company secretary or your solicitor. Then they will advise you how to position yourself. So at the end of the day, what I'm trying to highlight is the positioning that you want to be. By knowing your authority as a shareholder and by knowing your authority as a director will allow you to position yourself correctly in the company so that you, as much as possible, maintain control over the company. And to do that, one of the key things you need to understand as a director is that generally the director controls the money flow, the day-to-day operation. Yeah. So whoever controls the director, the board of directors, pretty much controls the day-to-day operation. You can do pretty much anything. You want to buy a new car for the company, you want to go for a company trip, it's all under the jurisdiction of the directors. Shareholders doesn't have the authority to dictate the day-to-day operation of the company. Okay? So that means whoever controls the shareholdership will get to dictate who sits in the directorship. And the directorship will then drive the company in whatever direction. So if you are a minority shareholder in a startup, how do you protect your position? Anyone? Yeah, you're in the board, but you don't. If I'm the majority, I can just remove you. What? Isn't it? Whoever holds majority here will then dictate who sits here. So if you're holding 30%, your partner is holding 70%. How do you control? How do you manage that? Yeah. If he decides to take the company's money and go and holiday in London or something, how do you do that? Right? So one of the solution is, of course, knowing. So you see, first you have to know, okay, I only have 30%. That means he, at any point in time, can change the composition of the board of director. So if he can change the composition of the board of director, means he can change who is the signatory to the bank account. That means the moment he takes control of the bank account, however he spends the money, he doesn't have to explain it to you. Okay? So ideally, you want to have a co-founder agreement which entrench yourself in the board seat. That means in the co-founders agreement, You say, I'm a shareholder, you're a shareholder, you have one board seat, I must be guaranteed one board seat. That way, you will always entrench yourself in the board. He cannot remove you. And then, in the same agreement, you want to mention that I must at all time be a co-signatory to the bank account. Okay? So you got, but as a majority, then you have this situation. What if my minority decides to leave? He's guaranteed one board seat. He has control of the bank account as well. And he's telling me, I'm not going to remove myself as a director. I am not going to remove myself as a signatory without you paying me 10,000 ringgit. What do you do? See, it gets very, very tricky, but that's why you need to understand. So then you can put things like, for example, that's where your co-founder's arrangement comes in. Now, there's a few ways to structure the co-founder's arrangement. Anyway, if you guys are taking photo for the slide, towards the end, what I'm going to do is I'm going to give you a link. You can immediately just go to that link, like our Facebook page, and download it will go into your phone immediately. Okay? So, this is just an example. When I say democracy, you can make it in such a way that if it's a 3-founder, you can do a 33 split. So that becomes a democracy so it's a majority kind of decision. So you structure it in such a way that only with the majority vote of the co-founders, things can move. Otherwise, it doesn't move. So you can structure it like that. Or sometimes in a 2-person composition, you may want to do a little bit of a dictatorship. Or even if it's a larger group, you want to have one person who will always have the final say. And normally in that kind of environment, you will have a strong leader who will have to make that tough call. And in that kind of setting also, we normally advise the co-founders to say that, look, if you're not comfortable with the democracy model, where you're afraid that there will be a deadlock, okay, you got to go for the dictatorship model. And you have to have faith in your leader. Whatever he does, it might be wrong, but you have decided to put your faith in his hands, so you got to just follow the driver, okay, since you're riding shotgun, unless you want to be the leader. So normally the leader will have to make the tough judgment call. Sometimes you can do a hybrid model, but normally hybrid model is for startup that has about 8 to 10 founders. These are normally when they want to endeavor in a big development project. So a lot of the co-founders are developers. So in that kind of setting, you will have a group that will dictate what's going on in the company, and the other co-founders are just following for the ride. So you can do that hybrid model as well. But the key point is that you must be very, very clear on what is the equity split, okay, between the co-founders. Because if you don't agree on that early on, it's going to be very, very challenging. And whatever you offer, you must understand that whatever percentage you give, you are giving away voting rights as well to them. And the moment you lose majority, that means you no longer have control of the company. That means you need another person's vote to get things done. Okay? Now, that's why a little bit of features introduced in your co-founders agreement can be very, very helpful, in that you can put vesting provision. That means they don't get all the shares outrightly, they get it on a tranche basis. That means you meet your milestones, or you meet your years of service, you meet certain targets, then only you will get your share entitlement. Otherwise, you got to return it back to me, or we will not give it to you. Either way. So if you have to return it back, it's called reverse vesting. But ideally, this is where it's very, very important for the majority. For majority, generally, they are the one who will stay behind when the company is not doing so well. It's always the minority that would want to leave, because they feel like, company is not going so well, I'm not interested, I want to go and try something else, or I want to get a job because I got a family to feed. So then they want to leave. But before they leave, they say, okay, I'll give you back all your shares, everything belonging to the company, but you got to pay me my salary. There was no salary agreed, but they will say, you got to pay me for the time I've spent for the startup. So they ask you for a ridiculous amount of money. So you're stuck in that position. What do? Generally, there's no agreement. So that's why it gets very, very difficult to negotiate that exit. So might as well pre-agree, because if it's at the point of exit, then you only want to decide what's the exit clause, then they will have the leverage. Because if you don't take back the shares from them, you cannot find new co-founders. That means you got to restart the whole company, set up new company and find new co-founders and lose all the data that you have collected so far. Okay, and then there will be some IP dispute, very messy. Okay, so that's why an exit clause to say that if you leave, all right, you will give back the shares, or I will explain a little bit on some of the example of exit clause. But that's where knowing how much authority you have in the company will determine what are the type of exit clause you want to impose against your co-founder or against the person who has the majority shares. One of the most common dispute that I see is, of course, salary entitlement. It's very, very difficult when at a very early stage you're not generating a lot of revenue, and one founder is expecting quite a high salary simply because he used to earn this much money in this particular company that he used to work with. So if you want my talent, you got to pay me this much salary. So it's very, very challenging when that expectation is set, but nobody is bringing out an expectation and put it in writing. So that's why you need to be able to do that. Yeah. For minority, ideally you want to have this thing called reserve matters. So that means at the shareholder level or at the board level, although you don't hold the majority decision, what you want to do is you want to put certain provisions where if you want to get it done, you got to get my consent. These are, for example, issuing new shares. Because majority will always have the right to issue new shares, which translates into you being diluted. Okay, so you want to be able to block that through the reserve matter. So there are items like, for example, acquisition of assets. If they are buying assets for the greater good of the business, fantastic. If they're trying to buy a BMW to show off, then you want to be able to block. So that's where reserve matter comes in. So anything that falls under the reserve matter will require your consent. Otherwise, everything is based on majority. So that's an example of maintaining control when you're the minority. If you're the majority, you want to try as much as possible to ensure items in the reserve matter does not impact your day-to-day operation. That means appointment of vendors below a certain amount. Maybe you don't need everybody's vote. You just need the majority's vote. Then you can move on. Or you can put no threshold whatsoever. Okay? Ideally, you want to structure in such a way so that your operation is not impacted. Now, when we talk about vesting, this is an example of a vesting provision where you say, okay, 25% upfront and the rest monthly or annually over 3 to 4 years. Another example is 50% after 1 year and the balance is 50% upon exit. That means when you sell off the company to a buyer. Now, this is just example. The beauty of the law is that the law doesn't dictate the exit, the vesting provision. Anything under the sun goes. So that's where a little bit of negotiation with your co-founder is extremely important. You want to find the sweet spot for them. Not too draconian that they would not be interested to invest their time into the business, but not too relaxed that they can get away with leaving the company with a lot of shares. Yeah? So there has to be that sweet spot where they get that penalty if they leave early, but they still get that carrot if they stay on. Okay? Now, how to determine that is always get advice or just try and negotiate the best deal that you can think. If you are the one giving the entitlement, of course you want as much as possible protect your position. But of course, that's where the negotiation skill comes in. So brushing up on your negotiation skill is as important as well when you want to do this kind of discussion. Okay? But as much as possible, try to be fair. Because when the terms are not fair, you tend to get some rebellion going on inside the company. Exit, extremely important. Even if you don't have your vesting provision, right? If you don't have exit, that's the worst thing you can do for yourself. Even if you're too lazy to curate your vesting provision, the worst thing you can do is not having an exit provision. If you have just one piece of paper that covers nothing else apart from the exit clause, then I'm happy for you already, because it's at the point of exit the day when your co-founder comes to you and say, hey, I want to leave the company, but I'm not giving you the shares because if this in the unlikely event or in any event, if the company is successful, I want my shares to be worth something. Okay, if you want it now, you got to pay me some amount. So that's where you will always have things like, for example, at the point of exit, all unvested shares will be forfeited, or all vested shares will be repurchased at value mutually agreed, or in absence of agreement, net asset value. This is an example. How you want to curate it is entirely up to you. So it's the same thing, you have to negotiate a sweet spot as well. Okay, something that is fair. I've done one case where we just flip a coin. I'll explain to you later. Sometimes we have a bad leaver, good leaver provision, where if you're a bad leaver, all shares will be forfeited. Doesn't matter whether it's vested or unvested. That means a bad leaver could be you were terminated, or you decided to resign before a certain period, or you were terminated because you stole some company's money, or you MIA, never attend, never do your job. You can put it under bad leaver. Okay, and good leaver is only unvested shares will be forfeited. So then the rest you leave with the, when you leave the company, you can keep it. But ideally, in all circumstances, I wouldn't advise you to allow any co-founder to leave the company with any shares at a very, very early stage. If they want to leave, give me back my share. So you either have a very draconian exit clause, which is fine, because you got to think about the future. So if they cannot bite the bullet, then don't join you in the first place. You see, it's a very good filtering process as well. If you outrightly tell your founder, look, you leave within the first 3 years, nothing, zero. See whether they want to accept. That means if they feel like after a year, I'll think about it, then this kind of clauses will not interest them, because they are not really into it as much as you do. But of course, sometimes you got to also think at the back of your mind, what's the leverage that I have? I'm not offering money. I need his skill. So a little bit of give and take is also important. Okay, so how to find that sweet spot, right? You need to really understand what's the leverage that you have, okay, and how bad the person wants to join you, and how much they hate their job. If they hate their job, it's much, much easier. Okay, so that's the convincing game. Now, these are some of the bad ideas you can do in a company. 50-50 split. I did mention democracy, but democracy is practical when you have 3%. That means 2% vote, majority. If it's a 2% and it becomes a 50-50, your likelihood of a deadlock is very, very high. Okay? So to avoid deadlock, never ever do a 50-50 split. Do a 51 or 49 split. That's fine. Because if you do a 50-50 split and you reach a deadlock, then you cannot get new investors. There's a lot of issues to resolve. So try and not do this. Another thing is draw a big fat salary. It doesn't look good on your books, and the investors will not be very happy. Not just investors, bankers also look into these things. 50-50 split, they won't give you loan if they look at, one, you draw a really big salary. Number two, 50-50 split. What happens if there's a deadlock? Nobody's going to pay my debt. I'm not going to give you my money. High risk. Right? So you got to think of that. Okay? And not having any exit plan is very, very dangerous as well. And not having an agreement is very, very bad. Now, a lot of people come up to me and say, Fareez, we're startups. We don't have money to have an agreement. So this is where you need to understand as well. An agreement is extremely important, no doubt about it. And no doubt if you hire a solicitor, it will be expensive. Okay? Even for us, a very, very basic co-founders agreement is about 2,000 ringgit. But we cover the basics, and you can at least use that for the next 12 to 24 months. If you don't have the resources to spend that much money, what you can do is just draft out a piece of document, cover one provision, for example, the exit clause, the vesting clause, and equity apportionment. Done. You don't have to have a very complicated 10-page agreement because you're not even there yet. Okay? You can always revisit the agreement. You can always have a supplementary agreement, a fresh agreement to overrule the old agreement. Ideally, you want to revisit the whole thing from time to time, depending on what kind of new endeavor are you going into, what kind of new business portfolio you're going into, or what kind of new investors you're bringing in. Normally, if you bring in new investors, they will dictate their terms, so you will then subscribe to their version of the shareholder agreement. But if you do equity crowdfunding, you get to dictate to the investors. All right? So in that kind of setting, you want to revisit the shareholder agreement. and your commitment from your partners as well. So that's why you don't need a perfect agreement from day one, but you need some form of agreement in writing. So you need to be able to sit down with your partner, bite the bullet and tell them, look, I'm not going to be able to give you this, or I'm not going to be able to give you this apportionment. Okay? If you don't deal with this early on, it's going to be a very big problem that it's a problem you can solve, really. Honestly, bulk of the time we are able to solve it. It's really a big headache that you don't want to endure because you got other things to look for. Okay, so don't waste time dealing with all this nitty-gritty administrative issue and focus on the business. So to do that, put it in writing. Now, reason why I always advocate for you to put it in writing and in agreement, not because you can take it to court. Who got money? We don't have the resources to go to court. But sometimes what you say in passing, okay, your partners will take it and hold on to it. And after 1 to 2 years or 1.5 years, he's not going to remember exactly what was discussed. You are not going to remember. And if you don't minute it, it's not in writing, not in email, not in anything, nobody's going to remember. So it's going to be a he said, she said kind of situation. And it happened. The dispute was just whether the apportionment 3.5% or 4%. It was just a difference of 0.5%. That was the only difference. But because of that dispute, all the other issues, like for example, I spend more hours for the company, I spend more time doing this, I close this client, crops up as well. So then it hampers the actual issue at hand, which is the 0.5%. So all of that could have been resorted if 1 year ago they put it in writing and say yours is 3.5, okay, and done. So that's why putting it in writing is very important. You can even shoot an email or WhatsApp conversation, but if WhatsApp conversation, you may want to save it. Okay. So that's why co-founders arrangement is something that you want to deal with very, very early and not deal with it when the business is doing better, because when the money comes in, try and negotiate, see what happens. All right? So it's going to be very, very challenging no matter how good your relationship is. Very rare, sometimes I see there's no problems at all, but there are very, very rare cases where everything is fine, nobody's disputing, no agreement, but is that the risk you want to take? So at the end of the day, when you're doing business, right, it's some form of risk assessment as well. Okay, you can just plow your way through it and see whether luck is on your side, or you can prepare for it. So my advice has always been prepare for it. So I'm also going to cover a little bit on fundraising issues. These are the common options for startup. I'm not talking about SMEs or private, public company. I'm just talking about startup. You can go for debt financing, either from banks or P2P lending. Okay, banks, you got to be at least 2 years in operation. So they want to see your 2 years audited accounts. But there are ways to circumvent it. That's where your record keeping is very important. Okay, banks will want to see some kind of money coming in and out. So normally what we will advise clients is always to structure your bank statement very, very nicely, where you bill consistently so that they can see every month this amount of money comes in. You may not be able to secure a big loan facility, but if you can secure at least 10,000 credit facility, right, that would contribute into the company's credit rating. So you got to see the company as an individual as well. And when the banks loan money to the company, the banks will do a CTOS search, which is the credit rating search. So if you don't have any credit history, what's the likelihood of you getting a big bank loan from them? Almost none. Even if your books look very good, they would most likely not allow you to get any kind of facility because they don't know whether you will pay or not. They don't know your paying behavior. So normally at a very early stage, you can start with something small, corporate credit card, term loan, credit facility. If you have credit facility, you don't use it, it will still appear on your record and it will look very nice. Okay? So then you can go for higher facility. Okay? Sometimes at a very early stage, the banks will ask for one-on-one. So you give them 10,000 ringgit, put in a fixed deposit, they will give you a 10,000 credit facility. Okay? But that 10,000 in the fixed deposit earns some money. Okay, whatever you spend there, normally if it's a 10,000 credit facility, 30 days is about $80 a month. That's the cost of if you draw down. Okay, so that's, for me, is really cheap. But what you want to do with that exercise is not to leverage so much on the money, but to create that credit rating, so that after your 2 years has ended, or when you need more money from the bank, it's easier for them to give you that money because you have a very good track record. Okay. Although a lot of people say that for startup you should go for VCs, PE, that's not an ideal solution to all your to your capital problems. Okay, because last year it was very good. VCs were throwing in money like nobody's business. This year it has slowed down, and I don't think next year is going to be any better. Okay, so you need to be able to diversify your capital income as well. So another way is peer-to-peer lending. It's just recently introduced in November last year. So you have 6 operators where you can crowdsource your loan money. So that means they will publish your campaign online and say you want to loan a certain amount of money. They will crowdsource the money from the public, okay? And then they will attach a percentage that you need to pay, and they will disburse the money to you once the campaign is successful, okay? The best part about P2P lending is that they don't have a minimum requirement. Minimum requirement is entirely based on what the platform operator thinks is suitable. So there's no bank negara regulation on the loan requirement. So that way, in your first and second year, you can gear up quite well, but a bit more expensive in terms of your interest rate, but the money is sourced from the crowd. So they are not as punitive as the bank when it comes to collection. I'm not saying don't pay, because it will appear in your CTOS as well. Yeah, but on top of that, they're not punishing like the banks, but you get to create your credit rating as well. Okay, so that's why for startups, of course, this is your first option. This is your second option. Either way, in your first and second year, I would recommend you to at least take something very, very small. Okay, just to create that. Equity, you can source it from VCs. Angels is a good option as well. ECF, equity crowdfunding, same thing like P2P. You create a campaign, you crowdsource the money from the public, and you offer them whatever equity you want to offer. Okay, or FFF, friends, family, and fools, because those are the only people who would be interested to invest in a startup. Okay, so another option, of course, is a grant, where you can get it from the G-Man. I'm not a fan of grants. I'm not saying don't apply, because it's free money. Never say no to free money. I'm saying is that don't be highly dependent on grants, because I have a lot of clients who receive government grants, takes forever to be disbursed, slows down the business. For a startup, momentum is very important. You want to be able to capture the market as fast as possible, as big as possible. So you want to cast your net very, very wide. But if the money takes forever to come in, you're going to have some issue with that. So that's why apply, go and get it, but try and leverage on this tool for your expansion plan. So this one is more like a bonus. Okay. Now, how you want to structure your financing is entirely up to how you want to run your business model. Okay. So your fundraising should fit your business model. Reason being is that you don't want to raise too much money, you don't want to raise too little money. One of the common issues with regards to fundraising is always signing the term sheet or the letter of intention. Letter of intention is normally with banks, yeah, when you go for bank loans, without negotiating or shopping. Because the banks you cannot negotiate. Actually, you can appeal on the interest rate. Yeah? So banks, when they come to you and say, hey, this is the letter of intent, this is your percentage, take it or leave it. No, actually you can appeal on the interest rate. Some of the ways I do that is go shopping first, see if I can find 5 banks to offer me loan. I show the one that has the least amount of interest, and I go to the bank that I like. Hey, by the way, this bank is giving me 5%, but I have good relationship with you, I want to give you the business, can you lower? So then they will submit the appeal. Miraculously, they say yes. So that's what I know. Unless they are not hungry for that kind of loan. Sometimes, like for example, when I do that trick, they say, sorry Fareez, we're not interested in this kind of loan anymore, because the bank has closed the books for gearing reasons. So then you got to move on to other banks. So a little bit of understanding and relationship with the bank officers goes a long way in securing your loan. Okay? But never ever sign the letter of intention without negotiating, without going shopping first. If you just get one option and then you just rely on that option, then you're going to have you're going to realize later that there's a very high probability it's a bad deal. When I say negotiation, also is term sheet from investors. A lot of times I find that founders will take the term sheet, immediately sign because I'm very, very desperate for money, okay, without even negotiating the terms. Reason being is that although a lot of investors will do this and they're not at fault or anything, they will tell you, by the way, this document is not binding. Okay, it's not, I cannot enforce it in court, which is true. Okay, but you sign it first. It's just a gentleman's handshake. But the thing about term sheet is that what they will do is, in a lot of cases where VCs or any fund entity, what they will do with that term sheet is that they're going to use that to go and get the mandate from their investment committee. So once they get the mandate, okay, to change anything, the fundamental terms in the agreement, they need to go back to the IC. If they are investing in 10 startups that is probably doing somewhat similar things, what's the likelihood of them going again to the IC to get the second mandate for you? Very, very unlikely unless you are very, very sexy. Okay? Not like sexy as in your idea is very sexy. In that kind of situation, normally you want to negotiate the term sheet before you sign it. Because once you sign it, very, very difficult, almost never happens that they're going to change the terms. This is what they're going to tell you. Okay, I can change, but you got to wait for me to go to the IC and see whether the IC approves. And then I don't know whether they actually go to the IC, but then they will come back to you and say, no, IC says no. Do you still want the money or not? Obviously, you're going to say yes. So you don't really have much leverage, but when you negotiate it earlier, then it's easier because then when they bring it to IC, they don't have to do it a lot of times. This is a one-time thing. Okay, so term sheet, very important. Valuation limbo. Reason being is there's always this issue, Fareez, how do I value my company? I have no idea actually. There's a lot of formulas that you can utilize to value your company. But for a startup, a lot of those formulas are very, very inaccurate. You can use 5 formulas and all will come up with a different result. What you need to really understand at the end of the day is agreed buyer, agreed seller. If you can get the investor to agree to your valuation, if you can get the banks to agree to a particular percentage, and you are okay with it, move on with that. Okay? Because if you're not comfortable, then you need to counter-propose the valuation. But otherwise, it's agreed buyer, agreed seller. So don't be bound so much by how I arrived to that figure. Because how you arrive to that figure is just a logical explanation to it. Because it doesn't make sense to go to investor and say, I value my company $10 million. And then they tell you, what's your reason? And say, because my feng shui master says so. Obviously, they're not going to give you the money, right? But if you say, I based it on this formula, then it's more likely that they will offer you the investment. Okay. A lot of times, poor record keeping would affect your fundraising capability. With the banks, no doubt. Even ECF, P2P lending will not touch you if your record keeping is rubbish. Okay? So it's very, very important that you do your bookkeeping. Even if you don't do your accounting now you can just input everything into a software, then they will automatically generate everything. But your bookkeeping must be done properly. Okay? Learn a little bit of bookkeeping, and that will go a long way in showing the investors your numbers, showing the banks your numbers, showing the operator, ECF or P2P operators your numbers. So you look more convincing and more attractive to be invested into. Okay? Because at the end of the day, it's dollar and cent. If you say you have this fantastic idea, it doesn't translate into dollar and cent, people are a bit hard or a bit skeptical to invest in you. Okay? Always have a cost-benefit analysis and financial modeling before you take any kind of fundraising. A lot of people think, I have this idea, I need this much money to execute it, and without this money, I cannot proceed, without even trying it out. The way it should be done is, I have this idea, let me give it a try and see how people respond to it. Then based on that response, you calculate how much is the cost to get that response. Okay? How much money do I need to spend then to get a bigger response? or bigger acquisition. So that's normally how the logical argument works with regards to investors. So you have this thing what we call a sunk cost fallacy, where you invest, you short sendiri. You think that you have the greatest idea in the world, and let's go fundraising, let's go borrow money from the bank, borrow money from investors, because although you are getting capital injection from the investors, normally it's a semi-debt kind of arrangement, so you got to pay them back at the end of the day. Okay, so you don't want to be fundraising money you don't need, or without realizing that, hey, I'm spending all this money to get data that to get things to achieve something that I'm not even sure is going to happen or not. Okay, so you want to fundraise so that you can spend money on things that you are very, very likely going to happen. So to do that, you need to test your idea out first before you even go for your fundraising. It's not for the investors. Investors, of course, they will ask you, have you tested out this idea? What's your data? But for yourself, before you gear up, you want to be very, very sure that the idea can fly. Because if it's not, then you're going to gear up a lot without realizing that it's going to affect you later on. Okay? So you got to be careful with that. Now, key points during your negotiation is, of course, how much fund you really need. Don't ask too much, don't ask too little. So your financial projection is very important, or your budgeting is very important as well, to identify exactly how much money you need. Equity and interest percentage, you need to iron that out very, very early. So when you're negotiating with the investors, don't worry so much about, do I offer ordinary shares? Do I offer RCPS? Do I offer those kind of things? Those terms are normally ancillary. The most important thing you want to get an agreement from is how much money they can give you, or how much money you need, and can they give you that money? So sometimes it's always a mismatch kind of situation. You ask from an investor, I want 1 million. They tell you, look, I can only give you 500,000. Then you have to think, 500,000, is it enough for me to execute the whole project? If it's not, then you're going to be short funded. Then you will not be able to deliver because you don't have enough funds. So you need to find the right investors, or investors that can fulfill that amount of fund that you need to propel your business. Otherwise, you just be fundraising for the sake of fundraising, and then investor will be asking you, can you deliver, can you deliver? Then you start over-promising. So you got to be careful with that. Okay? And of course, make sure that you know what are the rights that you are giving away. So a little bit of understanding on the corporate structure just now will tell you roughly what are the authorities you are giving away to the investor, and how will it affect your day-to-day operation. What's your commitment to the investor? Is there any repayment to them? Knowing that would go a long way for understanding and planning your business for the future. Okay, common mistake number 2, fundraise after running out of money. That's the worst thing you can do. You will not have leverage at all. I have a few clients came up to me and say, Fareez, we're out of money. If I don't sign this term sheet by tomorrow, game over. Then why are you talking to me for? Because you obviously have no interest negotiating. They say, oh, can you read this? See if it's okay. Does it matter if it's not okay? No, you will sign it anyway because you are desperate for money. So so always give yourself some runaway period before you have to go for your next fundraising, especially if you have no revenue or no profit. Okay? Common mistake number 3 is fail to seek help or advice. You see, the common misconception that I see in the startup community is that when I have term sheet, the first person I have to talk to is a lawyer. That's not wrong. Another person that you can talk to is other founders that have gone through investment round, especially if they have gone the investment round with the same investor or with the same banker. Normally they are quite familiar with the terms, and they're also quite familiar with what's the implication of agreeing with these terms. If you talk to them, then you know exactly what are you signing up for. Okay, so a solicitor is one option. Another option is somebody who has gone through the same kind of exercise. Okay, so always seek advice and help. If you're not sure, come to Magic, find somebody who is familiar with all the other startups and ask around who has received funding from maybe Axiata, Khazanah, Cradle, okay, and see what are the things that you need to look out for with regards to these investors. Sometimes it's not even on the agreement. It can be as simple as, this is an example, I'm not saying they are like this. Axiata can be a helicopter investor. That means they will breathe down your neck and asking you on a weekly basis what's going on with the company. Okay, you can only know that if you speak to a founder or solicitor that has dealt with Axiata. Okay, so a little bit of background check is very important as well. Now, some of the common agreements that you have is in startup we will cover, but I just want to tell you that there are, as a basic understanding, is that contracts can be written, oral, or implied. Okay, written is of course your standard writing form, but oral contract, that means if I promise you, hey, I'm going to buy your phone, 10 ringgit, that's a valid contract as soon as you agree to it. But the problem with oral contract is, first you got to have somebody to verify that it exists. So otherwise you go to court, he said, she said kind of situation. Then the court will have to look at the circumstances. Okay? And the biggest problem with oral contract is not about proving it alone. The biggest problem is the standard of performance. Okay? So say for example, okay, I want to buy your phone, 10,000 ringgit. You say yes, okay. Then you deliver me a handphone which is not functioning. If you put it in writing, obviously you will say things like, oh, you got to deliver to me in good condition. But in that kind of transaction where it's oral, normally you don't have that kind of discussion. So that's the problem with oral agreement, is that the absence of quality of delivery. So that's why writing is better, always better. Okay? A contract can also be implied, so you got to be mindful through conduct. So that means, say for example, you hire somebody, no agreement, nothing was said, he just comes in and out of and does his work. And then on a monthly basis, you pay him his salary. That's implied through conduct that he's an employee. That can be done as well. So you got to be mindful of your behavior when it comes to contract. It's not easy to imply a contract. There's a lot of things you need to do to prove it, but it's possible. So I need you to know that there's a possibility of how contract can be formed. Most important thing you need to understand if you're running a startup is that even if you have contract, you may not have the ability to enforce it, simply because no money. Okay? So then a lot of people say, then Fareez, then we don't need to have any contract. What's the point? We were not able to enforce it. Like I said just now, contract is not per se for the purpose of taking to court and enforce it. Sometimes contract is enough as a reminder for parties what was agreed a couple of years back, for example, or a couple of months back. So that's why you want to put it in writing so that all of this conversation is put on record. This is the biggest problem when you don't put your contract in writing, is that when you're dealing with, say for example, investors or companies or MNC, this week you deal with someone else, the following weeks you will deal with someone else because of the attrition rate that they have. So if you don't have things in writing, then you're going to have a lot of issues. Okay? So that's why putting things in writing is very important. And also your ability to prove. Okay? So knowing that, the common mistake that a lot of startup has is, one, absence of agreement. Another thing is the absence of evidence. So they don't keep their record keeping very well. So you don't have any proof that this client has ordered something. You don't have any proof that this client has agreed to a particular fee. So that's why always put things in writing. If it's an instruction or any order that comes in through the phone, put it in writing. Or otherwise, automate the whole system so that you don't have to worry about it anymore. But whatever you do, always put it in writing, especially if you're doing development work or any kind of service. Putting it in writing is extremely important, because in the absence of agreement, a proper written up agreement, you're going to rely on these emails to say what was instructed to you or what was ordered. Okay? So some of the common agreements you want to have is non-disclosure, employment agreement, supply and service agreement. Okay? Generally, people will derive this from templates. Just want to caution that most transactions are unique in nature. Try not to use template, but when you do, make sure you understand the content of a template, because some templates are curated in favor of another party. So you may use a non-disclosure agreement and you don't read it properly, but it's in favor of the other party and not you. So it can be bilateral or it can be a unilateral agreement. So read it carefully before you use it. So use it with caution. I'm not saying no. I'm not saying use as well. I'm saying use it with caution. Okay? And then agreement is only a piece of paper. What is most important is the structure of the transaction. You must be careful with the money flow. That means if you know that you are very small, if the client is very big, and if they don't pay, you don't have the capacity to sue them, you may want to ask money up front first. If they say no, then you have to take the risk of whether continuing and risk of not getting payment, or ask for half payment, or figure it out. So that's why the structure is more important than the agreement itself. Then you incorporate the structure into the agreement. That's how it's supposed to be done. Okay? Now, finding a lawyer is very simple. You have to have good chemistry. One thing I find that is extremely important is language. So if you don't understand what your lawyer is speaking to you, then you're going to have a very, very hard time dealing with them. So if you are more comfortable speaking in a particular language, try and find a solicitor who speaks that language. Because otherwise, there's going to be a lot of miscommunication happening. That's what I realized as well. So for clients that are very, very fluent in Mandarin, for example, and I can't speak Mandarin, I either bring my partner or I just refer them to another solicitor, because I don't want to be responsible for any mistakes. Okay? And personality, responsiveness is, of course, very obvious. Try as much as possible for startup not to engage so many third-party service provider. That means try as much as possible to consolidate your legal service, company secretary, audit, accounting under one roof. If you can find that, then that will be the best model that you can go for. And somebody that can understand your business. If you're doing a very complicated business that is regulated, they must understand your business. Otherwise, you'll be talking to a wall. Okay? So lawyers have different areas of practice. You have the corporate lawyer, criminal lawyer. So knowing their area of practice also helps. And just outrightly ask them, do you know this area of law? And testing them a little bit will go a long way in identifying whether that person is the best representative for you. Find out their fee structure, very important. Don't agree on the fees later. Some lawyers do that. They have a standard form. You sign, okay, I appoint you to a solicitor, then they have an hourly rate. Okay, every time you tell them, ask them questions, they will charge you on an hourly rate. Suddenly the invoice arrives in your office and you say, I never agreed to these fees. So make sure you know what's their fee structure. They have hourly rate, fixed fee or maximum cap system. And of course, value of service of a solicitor is not churning out templates for you, not churning out generic documents. The value in their service is whether they can solve your problem. Okay? So you want to try and make sure that your solicitor are able to very dynamic in their problem solving. And being able to be creative thinkers are very important as well. So there's no one solicitor that fits all kind of situation. So you need to comb through for a little bit. So don't settle for one just because he's the only one you can afford or he's a friend. So find somebody that can really help your business grow. Okay? That's it. Thank you very much. You can download the PowerPoint slide here. This is my website. You can get in touch with us anywhere here. Okay? And if you have any questions, yes. Sure. Uh-huh. This one is termination as an employee, is it? Oh, okay. So, one thing you have to understand, of course, when we talk about implied terms. So he was asking, what happens if the agreement is silent? Can we imply certain things? Okay, the thing about implied contract is, or implied terms in a contract, is that it's either by operation of the law, okay, or conduct of party. So if party never done anything to imply certain things, or if the law doesn't imply anything, okay, you cannot simply just create it out of the blue. So say for example, the agreement is silent about termination clause. The law says nothing about termination when in that kind of transaction. Okay, he's talking about a B2B transaction. Agreement is silent, law is silent, conduct of party doesn't show anything. What do? At the end of the day, it will be agreed between parties. If parties cannot agree, then the terminating party, okay, can terminate, and then the terminated party have the right to, of course, sue if there's any damages. So then you need to see the risk assessment. If I terminate this, what's the risk of damage that I have to pay to the other party? And am I willing to take that risk? Can sue lah. Yeah. Even if there's termination clause, I still can sue you. It's just that my likelihood of success in court is very little. Yeah. Then it depends on the discretion of the judge, how much they want to award. Okay. All right. Any more questions? Yep. Okay. Bank is a very, very peculiar creature in that they are also business at the end of the day. So they have all this so-called criteria that they will always put online in their brochure, and then when you go to the counter, they will say it with as much conviction as they can that this is the policy of the bank. But then belakang cerita or behind the scene, if they want your business, they will let go, they will ignore all of this regulation. Okay, because at the end of the day, they're business and they are not in the business of taking risks. So the moment they smell that you are a risk, they will not give you the money. But the moment they feel like, oh, this guy confirm can pay, they will give you. Okay, so that's why a little bit of track record, but this is the standard answer you will get from most banks nowadays. 2 years operation before you can even get a term loan. Credit facility, normally before 2 years, they will only allow a one-on-one. That means 10,000 in bank, in fixed deposit, 10,000 credit facility. In very rare cases, we manage to secure 1-2. That means 10,000 ringgit, you get 20,000 credit facility. Very rare, very hard. Okay, those kind of situation is normally they have very, very good cash flow. Do we have a little bit of time? I just want to explain why bank loans is very important. Or credit facility is very important for certain type of businesses, especially when you're dealing with stocks or assets that you are selling to customers. You don't want to use your own capital, which you can use to hire employees or whatever, to buy your stock. Because when you buy your stock, the capital is stuck in that stock until you can move it. Okay? Until and unless you can move it. So you want to try and use someone else's money, okay, to purchase the stocks and try and dispose it as fast as possible. That's the ideal way of doing it. But of course, you need to be very, very sure you can move the stock. So don't make your assumption of being able to move a particular stock simply because I think people would like this product. So you got to do your market research and know for a fact that this product is moving, that you have reached a point. Normally, you will leverage on credit facility when you know that demand is more than your stock. That's when the right time to leverage. Or if you have a very, very strong likelihood that if I can bring in the stock, I can push more. Right? But then you take risk. If you don't know, then the risk gets higher. So that's how you make the assessment when it comes to bank loan or any kind of financing. Can you make more money when you take this capital injection? If not, or the likelihood is very little, then bootstrap. That's the best way. Okay? But if your progress is too slow, but the demand is really high, then that's a really good indication to fundraise. And people will be queuing up to throw money at you. Okay? Any more questions? Do we have time for questions? Maybe we'll give that gentleman an opportunity first. Yes? Okay. Okay, there's a no correct answer for that. It depends. So like I said, this kind of transaction, it depends on whether you can convince them to say yes. Because whatever you propose and they say yes, yeah, legally you can do that. But I think there's a little bit of misconception there, because you are saying you are going to take 20% and then you're going to give your founders 15, and then the rest for investor. Yeah, so it doesn't work like that. You can't make provisions. You can, but your accounting is going to get a bit messy. So normally what we do is just, say for example, A, B, C, right? So 33, 34, for example. So then you have investor D. So then the adjustment will be 25, 25, 25. Assuming you are giving 25% to this investor. So initially you have 33, right? So you dilute it to 25. Then the next person comes in, DE. So it becomes 20, 20, 20, 20. Assuming you are offering 20% to E. So this one, they are diluted by 5% to contribute to. So that's how the dilution works. Yep. No, initially what you want to do is you want to do like a capitalization table to see that before the investor comes in, how much is my percentage? And then as I introduce new investors for a certain amount of percentage, how much is respective dilution? So it can be it can be 35, 20, 20, 25, depending on how you make the adjustment. Okay? Yeah, you can. Because the actual dilution will happen when you issue the shares to the investor. But you can make the provisioning in advance, just as a matter of easy understanding.
Okay, Fareez, I'm sorry because we have a mentoring session after this.
Yep.
I think we have to end it now. I'm so sorry, guys. But if you have any questions, you can email to Fareez.
Yeah.
All right. And thank you, Fareez, for being part of our speakers.
My email is just fareez@fareezlaw.com. Okay?
Okay. Right. Thank you so much, Fareez, for being part of our speakers in the symposium. Please give a round of applause to Fareez. All right. So again, please don't forget to fill up the survey for this session, and the redemption counter for gift will be is still open now until 6:30. So some cool prizes are Starbucks vouchers, Zalora speakers, PS4, iPod. So don't miss this opportunity. Okay. All right. Thank you so much, and see you tomorrow. And those who are going for mentoring session, please head to co-working space level 1. Fareez will be one of our mentors as well.